Today. Now, if you're listening Friday, we did a show pretty much dedicated to Common Core, and we didn't spend a lot of time on the nonsense that it is, because we spent a good deal of time on some things that we could do to, try to get this thing overturned. And one was, of course, email the governor, and you can do that at fl.gov.org, or is that .gov? Anyway, I'll look on my notes and see, but you can email the governor and then express your displeasure with him. And once again, there was a couple other things. You can sign a petition, and but there are other people doing things as well, and you probably haven't heard about this, so we're going to go to Jason-Hoyt to help us explain this to you. First of all, this is happening in Dixie County, which is up north of Gainesville, sort of between us and Tallahassee.
Yes, Dixie County, their grand jury up there. Just to back up just a moment a little bit, we always talk about accountability and holding our elected representatives accountable. What can we do? Right. And typically when you ask a Tea Party or 912 or AFP, Freedom Works, and these different organizations, what is the answer? It's always, well, we have to wait every 2 years and vote. We got to hold these guys accountable, and a lot of folks do the petitions and that kind of thing, but we have to wait for maybe, just maybe, if we elect enough of them, maybe they'll pass legislation to undo the damage and restore our rights, And so I've been doing a lot of research trying to find other ways, because you can't convince me, after all the founders did, that the system they put into place was where we have to wait every 2 years for an election. And so there's an organization called National Liberty Alliance, .org, that they're really encouraging people to get re-engaged with the Fifth Amendment of the Constitution. Fifth Amendment says no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or an indictment of a grand jury. Grand jury in common law is 25 people. We, the people, getting together, and we always hear about indictments, and we just heard one over the weekend about Rick Perry. Yep. And an indictment is where a prosecutor, or in that case a district attorney, comes forward, goes to the grand jury and says, here, we've got evidence of corruption. And they essentially, a lot of times you hear them about they can indict a ham sandwich,
Normally, because you only get the one side of the argument in the grand jury. You get the prosecution side of the argument.
Correct. And to be clear, and society doesn't understand this, the news doesn't say this, but in an indictment, all they're saying is there's enough evidence to then send it to trial, to then be judged by a jury of your peers and determined guilty or not guilty. An indictment is just, there's enough evidence. That's why they only hear one side. Right. But the word that is often missed is presentment. A presentment is where a grand jury, based on their own initiative, whether they hear of criminal activity from a member of the public or they witness it themselves, they have an obligation in their oath, and even in the Florida statute, they have an obligation to begin investigating in their own initiative. And this happened in Dixie County. The Dixie County grand jury foreman a couple months ago heard about some criminal activity. He tried to convene the Dixie County grand jury, and the state attorney kind of got in the way, a little bit of resistance there, obstructed, if you will. And so they had a meeting, kind of a town meeting, if you will. 25, or actually more than 25 showed up. They elected 25 new jurors for the People's Grand Jury under common law of Dixie County. They met at the courthouse last Thursday at 10 a.m. Grand jury deliberations and votes are still kept secret, but what came out of it was filed at the Dixie County Clerk of Courts. Dana Johnson stamped it at 4:31 p.m. Friday. 2 true bills of presentment. The first one against State's Attorney Jeffrey Sigmeister, charging him with obstruction of justice and jury tampering.
For not allowing the grand jury to pursue this.
Because according to the U.S. Supreme Court, U.S. versus Williams in 1992, Scalia wrote, the grand jury requires no authorization from its constituting court to initiate an investigation. That is what a presentment is. And they tried to do that, and he obstructed.
And what was the second?
The second one was bribery for the implementation of Common Core.
And this was what they wanted to investigate originally, I take it.
I would imagine so. I don't know if they heard other cases or other issues, but that is what was voted upon, and that's what came out of that grand jury.
So we're assuming that this is what the original foreman, the criminal activity that he had caught wind of, was evidently bribery having to do with Common Core.
Yeah, and I've heard this argument before, where, race to the top was the Trojan Trojan horse that snuck Common Core in. Race to the top funding. We want federal money. You know.
Well, I know a lot of people would call that bribery. That'd be political bribery, but a grand jury to charge bribery, you would think that this would be something under the table, cash money type thing. Is that what we're talking about here?
No, when you look at the legal definition of bribery, it doesn't have to be cash money under the table. It's actually money for favors, and when I say favors, it doesn't have to be personal favors, but it's public money. So essentially what they're alleging is that because of Race to the Top, a state said, yeah, give me the money, and yeah, we'll go ahead and accept Common Core. That implementation, and actually I received copies of the true bills, and they go into detail on all these different charges, and it's fascinating to see what's happening, where the people are standing up and the people are saying this whole statutory and regulatory industrial complex controlling our Fifth Amendment grand juries, obstructing them and not letting us, we the people, provide feedback, consent to the governed of what's going on and to what we're going to be held to account. I think it's phenomenal. I think it's awesome.
You say they, in the first presentation, they named the state attorney who got it, the prosecuting attorney who got in the way. Did they name people in the second presentation?
They did, and it's quite a list. They listed all of the school board members in Dixie County. They listed the State Board of Educators. I can't remember the names offhand. They also listed Governor Charlie Crist and even Governor Rick Scott for further implementation.
Okay. How is this different, though, than what's happening in Texas? Because if they're claiming that these officials were bribed because of the federal enticement of the federal dollars, isn't that sort of the same thing that they're in I know the circumstances are different, but what we're talking about here is a political difference becoming now a criminal issue.
You brought up Texas. I mean, when you look at Texas, that's a district attorney that brought the grand jury together, presented information, and you know how grand juries are today. Well, yeah, they're like rubber stamps.
Well, sure.
In that Democrat county, I'm sure it's a political motivation there.
Right.
The idea that, and again, I don't know all the facts regarding what happened in Texas.
Right.
But the idea that he's saying basically you need to step down or I'm not going to fund your office.
Right. So, and the difference in this case would be that it's the people who are objecting to something that the government have colluded to do, whereas in that case it's a political vendetta, so to speak.
Correct. And look what the founders put in place. I mean, do you think the founders created the jury system? I mean, that came out of, call it Magna Carta from 1215. Section 62 of the Magna Carta talked about the 25 barons. And for centuries, groups of people got together as the grand jury to be that buffer, which is actually the words that Scalia used. It's that buffer, that referee between the people and the government. And based on their own initiative, they can reach inside the government and root out corruption, and that's what the presentment power is. In 1946, however, the Criminal Procedures Act of 1946, they left presentments out. They didn't change the Constitution. They didn't make them illegal. They just left them out. And in a footnote in a law journal review, they said presentments are obsolete. So,
in other words, legally speaking, it's still an option.
Absolutely.
What would be the next step? Now that they've made the presentment, what happens next?
Well, I think today they might be presenting that the copies of what was filed at the county clerk. They're giving it to the sheriff and saying, "Sheriff, arrest these folks."
And if he doesn't?
And if they don't, he probably gets on the list for obstruction of justice. Because at the end of the day, even in the Florida Constitution, we are a common law system. We are a common law state. And when 25 folks got together as the People's Grand Jury under common law of Dixie County, and they voted anything other than that, people are obstructing justice. So, and this is going to go to the state level. This is going to go back to the federal level. Well, and what do we have on our side is U.S. versus Williams, 1992, Supreme Court.
One way or the other, this is going to end up in the courts, obviously, because they're going to have to determine, first of all, the validity of the act to begin with, and then the merits of it. So,
yeah.
All right, well, we'll just have to keep...
It's fascinating. I'll keep you guys apprised of it.
Please do.
Thank you for the opportunity today.
All right, well, thanks for keeping us up to date on these things out there. All right.